Hi, I'm Ben Valdes, and I'm running for chair of the Train Operators Division. The nature of the beast in our system is that in order to get something, we must negotiate something away, or at least that's what the MTA wants us to think. However, there are many things that we aren't getting that we are entitled to by law, and are already in the contract that the MTA completely ignores. Let's start with health and safety. Assaults are covered under Title 12 of the New York Code of Regulations. The MTA must have a written plan to combat assaults, and this plan must be posted conspicuously in our crew rooms. This law considers the MTA to be in serious violation if they fail to 1. Develop and implement a workplace violence prevention program, and 2. Address situations which could result in serious physical harm. I believe examples of these situations should include being told by RCC to investigate unattended bags and reports of criminal conduct. We are not bomb-sniffing dogs. These are police matters. This law also states that employers at sites where there is a developing pattern of workplace violence incidents which may involve criminal conduct or a serious injury shall attempt to develop a protocol with the district attorney or police to ensure that violent crimes committed against employees in the workplace are promptly investigated and appropriately prosecuted. We know this 7-year maximum penalty is a joke. Nobody gets that much time, even if they get jail time at all. On to OSHA violations. My biggest pet peeve is structure walks. I knew the very first time I did a structure walk that it had to be an OSHA violation, and I was right. The OSHA standard regarding holes on a walking working surface states that a gap of 2 inches or larger constitutes a hole, thus must be covered. The MTA has not only us, but track workers, contractors, and so on, walking over tens, if not hundreds of thousands of unprotected holes. The OSHA standard regarding dangerous equipment, which includes third rails, states that the employer must ensure that each employee is protected from falling into or onto dangerous equipment unless the equipment is covered or guarded to eliminate the hazard. While they do have protection boards over the third rail, it only covers the top of the third rail, and thus it is still very possible to come into contact with it, meaning the hazard has not been eliminated. By the way, none of our tools are insulated as required by OSHA standard. In addition, requiring us to walk on tracks in inclement weather, for example, to push down frozen stop arms, is a clear violation of OSHA standard regarding inclement weather, which states that the employer must ensure walking working surfaces are maintained free of hazards such as snow and ice. They don't even give everyone snow cleats, which is a violation of the OSHA standard regarding PPE. Having us isolate cars with human waste, such as vomit, urine, feces, or blood, is a violation of the OSHA standard regarding hazardous waste, because it exposes us to possible contact with potential infectious waste without any PPE. There is no way to avoid it when you have to walk around the entire subway car to cut out each and every door panel, including the end doors. I filed an OSHA complaint on all of these things, but they're being ignored by PESH, the agency that handles OSHA complaints for New York State public employees. If the MTA claims there's no way to fix these problems, then we need to demand hazard pay. Work train operators should already be receiving hazard pay for the deplorable conditions that they work in. Lunch breaks. This too is a health issue. Before I started working here, I never had a job where one of the main functions of the supervisor wasn't to make sure everyone had a lunch break every day. New York State Labor Law 162 guarantees the right to a lunch break of at least 30 minutes for all employees. The New York State Court of Appeals has ruled that for our own health and welfare, this right cannot be waived. Yes, we get paid for lunch, but that is because we waived certain things in Labor Law 162, such as the right to a second lunch period for certain jobs and the right to a 45-minute lunch period for other jobs. The MAC. Now, I just went through all the ways the MTA violates our health and safety, yet they put us through the ringer in the name of customer safety. They will let us pass out from not having a lunch break or from working in extremely hot cabs, but God forbid you have sleep apnea. I believe the only medical exams that should be done are the ones that can test the actual ability to perform the job. Exams such as EKGs, blood pressure, glucose testing, and sleep apnea are, in my opinion, a violation of Title I of the Americans with Disabilities Act, which states that such invasive testing can only be done if there is a business necessity. They test us in the name of safety, but I don't believe there is a business necessity when we have a dead man feature, signal protection, and a conductor to pull the cord if we're operating recklessly. Furthermore, why are they testing conductors and tower operators? If a conductor passes out, either the doors won't open or they won't close, and the train operator can key open the doors at the next stop. If a tower operator passes out, even onto the machine, the fail-safe mechanisms will not allow the machine to line up two trains into a collision path. Even if we can only get the exams eliminated for conductors and tower operators, this would still be an enormous victory. The salaries of these positions are much higher than that of cleaner and station agent, to which most medical reclassifications are assigned. All they care about is preventing a delay, which I believe is an insufficient reason to test us medically. The EEOC has even written in an unofficial opinion letter that they believe the position of bus driver is not a position affecting public safety, thus ineligible for invasive medical testing. Bus drivers! They have no dead man, no signal protection, no safeguards whatsoever for an incapacitated operator, and even the EEOC says it's just not that serious. The FTA classifies many positions as safety sensitive, but this only means they are able to test us for drugs and alcohol. It has nothing to do with medical testing. The MTA has many positions which fall under the safety sensitive classification, yet they only test those of us in a position to cause a delay if we pass out. I spoke to someone on Facebook who works as a rail operator on the BART system in San Francisco who says they don't test them at all for any medical condition after they are hired. And I'm quite sure they don't have the same safeguards as our system. Speaking of which, FRA regulations for major railroads, which can reach much higher speeds than our system, don't have stop arms to trip their trains, and can possibly run into cars at railroad crossings, only require testing for vision and hearing. Our contract does not give the MTA the right to do invasive medical testing. There is a clause in the contract that allows them to medically test OA employees, but no such clause exists for TA employees. They are illegally asserting management rights with us, but gave OA the opportunity to bargain it into the contract. This is a violation of public employment contract law. The MTA has also begun a program where in order for someone with an injury on duty to collect workers' comp differential, they must sit at PS 248 for 10 days, citing the section of the contract that states that they can require an employee to do light work when the employee cannot perform the essential functions of their job. Yet the MTA puts people out with no work available when they have a medical condition that they deem unfit for duty. Trammell and I have filed a grievance that would allow people deemed unfit for duty by the MAC to be able to perform the light work being done at PS 248 for 10 days. In addition to fighting this with the Americans with Disabilities Act and contractually, we must also turn the tables on them. If they're going to put people out of work, they must realize that we all came here healthy enough to work. So if someone is suddenly unfit for duty, it must be the fault of the sedentary nature of our jobs. An article I read recently stated that sitting is the new smoking, meaning that the fact that our jobs have us unable to move around is increasing our likelihood for conditions such as high blood pressure, heart disease, weight gain, diabetes, and sleep apnea. This article also mentions the court's new willingness to award workers' compensation claims for sedentary occupations, We must begin applying for workers' compensation when we are put out no work available. You are to be paid for all time worked. That is the most basic principle of the Fair Labor Standards Act, and it is the ruling of an arbitrator in 2007 when the subject first came up. Do not ask the dispatcher what time your train was clocked in because it doesn't matter. You get paid to sign out, to fill out the exemption claim form, and any other job-related duties such as keying open doors or answering customer questions on the way to the dispatcher's office. A train operator at top pay who gets cheated just 5 minutes of overtime a day would be cheated of about $1,256.67 over the course of a year. No joke. We are tired of the MTA blatantly ignoring this arbitration award, and we are ready to take this to court if need be. I have found numerous other contract violations. One is that people are falling to the board on Sundays and holidays, even though the contract specifically says that if there is a suitable job on your line or section, you must be assigned to that first. I know they are violating this because people are falling to the board when a GO job gives their line extra or X jobs, yet they're assigning these jobs to extra people. That's just laziness on the part of the crew office. Another violation is the deadhead chart. Forget for a minute that they haven't come up with the new deadhead chart yet. That's a whole nother violation. The part I'm referring to is where it says, a train operator ending his or her run at a terminal other than that at which the run started shall be paid for the time required for him or her to return to the starting terminal. The time so allowed shall be the scheduled operating time between the two terminals, and for the purpose of computing overtime, it shall be considered as actual working time. What this is saying is that jobs with 1.5, 2.5, or 3.5 trips aren't even supposed to use the deadhead chart. It's supposed to be the scheduled operating time between the terminals. I did the math on a few of those jobs, and it appears they're using the deadhead chart to figure out the pay for these jobs, and anyone with a pick job that starts at one terminal and ends at another is likely being cheated. The YX program. The contract states, if a run or trick in any classification of work is left open for any reason, it will be put up for bid within 1 week, shall be advertised for 5 days, and will be awarded within 5 days after the close of the advertisement. What it doesn't say is that if the MTA wants to use our switching jobs to run a YX program, they can just leave those off the bid sheets. Yes, I know they can hold 35% of those jobs contractually, but that only applies to the pick, not the bid sheets. New hires. Why are people who have never touched their sick leave being kept on the 30% sick list for 3 years? The 70% provision says, this provision shall apply to all employees who have passed probation and worked through 1 full leave year. The foregoing threshold shall be adjusted on an annual basis such that 70% of employees will be subject to these exceptions. So worst case scenario, you were hired on May 2nd, 2018. So when they do the adjustment on May 1st, 2019, you just missed the cutoff because you don't have a year in. At the very latest, you should be on that 70% list on May 1st, 2020 when they do that next adjustment. So last week I had to take my wife to the hospital. Don't worry, she's okay. What we both celebrated about that night was when we left, they told us our copay for the ER was $0. In my opinion, we have great insurance. Don't let the MTA ruin that for us. I've seen people on Facebook say that certain things that were covered by Blue Cross and United aren't being covered by Aetna. This is not cool and is a violation of the contract, which says that the value of our benefits must not be decreased. If you have experienced a decrease in benefits, we need to grieve that immediately before the lowered benefits become the norm. Okay, so here's a topic I don't like to talk about. Discipline. And it's not because I don't have any ideas on it. It's because we'll have to negotiate away something to get any real change on this issue. 2 main things have to be changed. First, we must get paid whether we win or lose the case to appear at these hearings. Once that clause is in the contract, the MTA will be much more likely to settle the minor infractions in the field where they should be, instead of down at 2 Broadway. The next thing that must be changed is to have a third category or track of discipline. They are putting all violations outside of time and attendance in the same category, which allows them to add up much faster and in turn allows the penalties to rise much faster. You can be written up for a uniform violation, and if you had a previous write-up for something like a wrong lineup, you could get more days in the street for having your shirt untucked than you did for the wrong lineup. Does this system make any sense? That being said, the MTA still does have to adhere to case law when it comes to penalties. There's something called the Pell Standard of Fairness, which courts have ruled that if the penalty is shocking to one's sense of fairness, it must be overturned. In addition, according to civil service law, they can only discipline us for misconduct or incompetence. Do you think dropping the master controller is really misconduct or incompetence? I don't think so, and past practice indicates that this was always given a re-instruction. Now they're trying to give you 5 days in the street. I believe I'm the best candidate for this position. 3 of my opponents are in some way connected to the incumbents. Richard Richards is running with Crystal Young. Dwayne Sorrentino is running on Kia's slate. Zachary Archidiacono is running with Joe Costales. Canelo Gomez, I actually like his fight, but he's way too reckless with the way he talks about job actions and we have to be very careful with stuff like that because the strike in 2005 almost crippled our union. We're still dealing with the effects of it today since we lost the right to dues checkoff for a while. Mr. Gomez, I believe, also does not have the breadth of knowledge that I do when it comes to the issues. The MTA has us thinking that we have to negotiate to get a guaranteed lunch break and that we can't negotiate over medical exams when in fact it's the exact opposite. We can't afford to have reps in there who don't study their craft anymore. While I may be a quiet guy, I do have the knowledge required, and I have been coming out of my shell, like my little buddy over here. So if you would like to vote for me, I'll be in the independent section on the right. I'm still a member of Progressive Action and fully endorsed by Tremel Thompson, but the Elections Committee took away our slate status when our candidate for recording secretary was disqualified. So if you would like to vote for me, that's where you'll find me on the ballot. Also, if you would like comprehensive versions of my research, please read my brochures. I have left them in many crew rooms and I will be bringing them to more places. I would really appreciate your vote. I'm Ben Valdes. Thank you.